Okay, we're good to go. Excellent. Look, a very, very warm welcome to everyone to the Bar Standards Board. I'm Mark Neal. I'm the Director General of the Bar Standards Board. Particular welcome to what is by a country mile the best supported Bar Standards Board event ever on tech at the bar. I put that down to the quality of our panel, the intrinsic interest of the subject, and to the great research by Spinnaker, which Emma will be talking about, the take-up of technology at the bar. And I guess thinking about this, one of the lessons of history is that technology does not automatically translate into higher productivity and better services. I think it was the great American economist Robert Solow in the 1990s who said, you can see the computer age everywhere except in the productivity statistics. I think the kind of message there is that it does take time to master new technologies and to work out how to apply them effectively. Time, on the other hand, is not something that we have. We are actually under pressure to adopt and make use of these technologies. The technologies themselves are changing rapidly. Consumer expectations of the services they should expect from the legal services sector and from barristers are changing rapidly. And the imperative for economic growth is with us here and now. So it really is important to look at and understand how best the new technologies, particularly AI, can be harnessed to improve the productivity of barristers' services and the value and responsiveness of the services that barristers provide to consumers. That's where the Bar Standards Board comes in as a public sector, public interest regulator. Our interest is ensuring that those technologies and those opportunities are seized in the interests of the consumers of barristers' services and in the interests of an efficient justice system. You'll probably be relieved to hear that we're very clear that the answer is not more regulation and more rules. On the other hand, it's reassuring that the research tells us that regulation is not one of the barriers either to taking up the new technologies. But the answer does lie in building a better understanding among barristers themselves, among suppliers to this market, among academics, of exactly what the opportunities are of the new technologies and what the barriers to the adoption of those technologies are, and how collectively we can overcome those barriers. We know that one of the barriers is not barristers' willingness to innovate. Barristers do, as the research shows, take up many new technologies, but there is definitely a barrier in terms of scale, in terms of the fragmentation of the barrister market. And I'm really hoping that in the course of this evening, we'll get some really good debate about how we can overcome that barrier of scale, both for the bar itself, but also for the suppliers to the bar. So without more ado, I'm going to hand over to our chair of the evening, Ruth Pickering, who is one of our lay board members, but more appositely for this occasion is also the managing director of Uncover AI. So absolutely the ideal person to lead us into the discussion. Ruth.
Fantastic. Thank you very much, Mark. And just to reiterate Mark's very warm welcome to everyone who's found time to join us here in London and online. So I think we're here to talk about innovation and technology at the bar. One of the most important things about successful adoption and innovation itself is, of course, collaboration. So we're delighted to have so many people participate this evening. It's a brilliant start. I know some people have also rescheduled their diaries to make time to attend, so we really appreciate that. So before kicking off with the research overview, I'd like to introduce you to the panel. We have two people to my left, but I'll actually start off with the two panelists who are joining us remotely. So we're delighted to have Alexandra Vajicic, Director of Law Tech UK, and also Dr. Chris MacLeod, who is the Principal Lecturer at Manchester Metropolitan University School of Law. So they'll both be online, so they'll be answering questions during the panel and then when we move over into the audience Q&A. And then here in the room to my left, we have Andrew Thornton Casey, who's a barrister at Erskine Chambers. And our fourth panelist is also the lead researcher on the project. I'm delighted to introduce Gemma McFadden from Spinnaker. And Gemma, I'd love to hand over to you to present the research overview. Thank you.
Thank you everyone for joining us tonight, everyone who's online and in the room. And thank you first of all to Mark and the Bar Standards Board for supporting the profession with this important research. And thank you to everyone who took part, whether you are a practitioner, a stakeholder or tech provider. I hope I've done justice to your insights. And I'm sure in this room will be people not shy to tell me if otherwise. Ruth has already outlined the agenda for tonight, and as the report has already been published, and hopefully you've had a chance to review, let's dive straight into the research findings. So we started with a literature review, and thank you to my colleague David Bish, who is hopefully dialing in from Canada for this. We found that there was very little research specific to the use of technology by the bar. So we're very grateful to colleagues at the SRA, at the LSB and at the LSCP for their research, which really helped us to further our understanding, to identify gaps and generally frame the areas of interest. We were also interested in understanding how innovation and technology is driven in other jurisdictions, including Canada, Singapore and France. Building on the literature review, we spoke with 12 stakeholder organizations. And again, we wanted to delve really deeply into their perceptions of technology and really discover the areas that we wanted to investigate in the practitioner interviews. We wanted to talk about and identify, was it barriers to implementation? What are the drivers of change? What are the benefits of technology from their perspective? We spoke to vendors, technology vendors, and we drilled down our 5 interviews into 3 case studies, which are in the report. And again, we were interested in how they approached the market, how did they find the regulatory context for their technology. And I wanted to make it clear really at this point that our intention was always to undertake a qualitative project rather than quantitative. We wanted to explore the perspectives of barristers, of chambers, and really probe around the motivations, the challenges to capture those richness of experiences with technology and the decision making around it. So in terms of the practitioner interviews, we conducted 30 semi-structured online interviews last summer. Participants self-selected from an email invitation from the Bar Standards Board. Participants were qualified, and we used purposive sampling methods to make sure that we spoke to and included a representative mix of different sizes of chambers, different practice areas, and different roles within chambers, including clerks, cases, head of chambers, and a number of operational roles as well. Find, in terms of what we might call the current state of play, or the technology setup of the participants. And do bear in mind that this is really a snapshot of the 30 practitioners that we spoke to, although we do consider this to be a fair representation of the wider profession. So we started with quite a broad definition of technology. And luckily, Henry and I will spare you the endless discussions we had on law tech versus legal tech. But suffice to say, the profession don't see those definitions in practice and tend to include in their understanding anything and everything that supports them in their practice. as helpfully summed up by the advocate at the Paris bar who I spoke with. I think the point being that technology doesn't have to be innovative or disruptive to be impactful. So I've attempted to categorize the technologies that we discovered under being barrister-led or being case or practice area specific, and those which are managed or implemented more centrally across chambers, such as case management. Starting on the left-hand side, if we were to take self-employed barristers as the majority of the profession, 80% of the profession, it's very much a bring your own device scenario, and chambers will support that. So we had all sorts of combinations of Macs, PCs, desktops, iPads. The majority of participants are working completely paperlessly, and there was widespread use of video conferencing. 97% of barristers are video conferencing with clients, and that is greater in number than solicitors who are using video conferencing. And as one participant commented, COVID certainly put the jetpacks on that. Majority of barristers are routinely using digital bundles, PDF tools, cloud storage, and there was quite a lot of use of microtech in areas such as productivity, timekeeping, receipt management, although fair to say, these is quite a manual process for many, not very systematic, and tends to be quite ad hoc. In terms of AI usage, we did find that barristers were using tools like ChatGPT at Microsoft Copilot, and it was generally viewed as a helpful assistant, especially for more repetitive tasks such as transcription, summarising. And it's also being used by barristers in services such as Lexis Plus AI. Participants felt that AI, perhaps unsurprisingly, is not going to replace the profession. But if I can share with you a quote from one of the participants, AI won't replace barristers, but the barrister who uses AI will be able to replace those who don't, who will be able to increase their income and their market share. So that was from an employment barrister. At the chambers level, many respondents reported that it was easier to implement centralised systems when it comes to employees of chambers rather than members of chambers. And so these are the systems that run across chambers, cybersecurity being the biggest example. Most people had invested significantly in cybersecurity in the last 2 to 3 years. But also we would find case management and diary management in that sort of bucket. What we didn't find much evidence of, and certainly the smaller sets, is this emerging technology across the bottom, such as the use of workflow tools, for example, to put together chronologies, to assist with summarising, drafting, marshalling evidence, things like searching phone records. Similarly, there were few examples of more strategic deployment of technology by chambers, for example, client onboarding, automated client care letters, or technology to support clients with direct access. And we will come on to some possible reasons for that. So when we asked about the benefits of using technology, and there was quite a lot to discuss, I've endeavoured to group them into these 6 main sort of areas. So first of all, if we take working with clients, participants agreed that the technologies they've used has helped them to attract new clients, to be more responsive to client needs, to improve the speed of delivery, and also the quality of legal services provided. One example is a corporate barrister who described how they have an online portal for the client that provides management information for the client in terms of case progress, risks, budgets, deadlines, to give them that visibility. And another employed barrister explained how they're using chatbots to serve consumers and manage those out-of-hours inquiries that then enables his team to focus on reaching harder queries sooner. In terms of reducing document overload, there was definitely a sense that storing documents in the cloud and sharing documents that way has helped with managing the volume of papers, and also using live documents can help with version control. But the counterpoint for this, which I'm sure many of you will recognise, is that for many barristers, email and technology has worsened the bundling process. And several barristers talked about increasingly receiving a higher volume of documents via email, bombarded by extraneous information and told by law firms to make your own bundle from 557 emails with nested attachments. As one barrister commented, the sheer amount of data is turning disputes into an endurance contest. Similarly, a pro bono charity we spoke to explained that they have had to recruit additional resource to combat this specific challenge of data overload. So yes, this is a byproduct, an unwanted byproduct of technology, but it is also a frustration that appropriate technology could solve or cut through. Fair to say there were grumbles about email and how it is an inefficient tool, and many forward-thinking chambers are thinking about ways in which they could replace that. In terms of fair allocation, reallocation of work, using chambers systems such as Dropbox or SharePoint make it much easier to reallocate a barrister when that changes, so it's an instant reallocation. In terms of risk and data security, participants pointed out electronic files are much more secure than paper. And they don't get left on a train, or they're not visible through chambers windows. Documents in the cloud are more secure, they can be encrypted and protected, and from a disaster recovery point of view, they are backed up. The downside is what we came to call the travel lodge problem, where having documents in the cloud is fine until you're in Cardiff the night before a trial and you're locked out of chambers or the server goes down. And understandably, barristers can be reluctant to rely solely on technology in those situations. In terms of EDI, many participants reported it's much easier to work with PDFs in the cloud and use file transfer services like WeTransfer and Dropbox, rather than wheel about large bankers' boxes via couriers or taxis. And remote hearings too have significantly reduced the impact of driving or taking the train to Preston or Bristol for a 3-minute hearing, enabling barristers to maximise their diaries and save time. Printing has been a significant expense, which many chambers have now been able to save on, and not just printing, but the photocopying, the courier services, and the secure shredding is an expensive cycle. In terms of efficiency, saving time and increasing billings, I spoke to one commercial chambers who said that once they had put in time recording software, they were able to increase their turnover by 20%. They really understand that as a sector, barristers probably undervalue the time that they put into cases, and this gives them a way to recover some of that time. And interestingly, a small chambers that I spoke with in Birmingham explained that when there are more efficiencies in chambers, when things are more streamlined through technology, clerks are freed up to work on social media, to evaluate more strategic profit goals for chambers and respond to client calls, which is a much better use of their time. So we know from the research that there are benefits to the effective implementation of technology. I would say that barristers are curious and open-minded and can be agile. So why didn't we see more evidence of transformational technology? Which brings us on to the barriers to adoption. Legal regulation was not identified as a barrier to technology adoption, whether that is regulators of the legal sector or regulation more broadly, such as GDPR. And that agrees with the LSB's findings in their survey of 2023. But for me, it seemed to come down to the self-employed nature of the profession and the individual work styles of barristers. And we did come across the perception for some that the available technology doesn't currently align with the bespoke and creative nature of their work. And due to the way chambers are structured, there is limited funding and time for experimentation. Time out of practice time is lost income. Solutions must be relevant, beneficial, and easy to implement. Chambers typically don't have discretionary spend for pilot schemes and speculative investments. Even with funding, the cost of adoption is another barrier to technology. Head of operations, many of them commented that they need the capital not just to purchase the technology, but to maintain it, to implement it, to upgrade it. And that can be difficult to justify in some areas of practice. We know that chambers often outsource their IT to external providers who mainly handle the day-to-day user support. So there's less focus on aspects like long-term planning and systems integration, something which law firms are better set up to deliver. The larger chambers are more proactive here and were able to take a longer-term view. So we found, fair to say, I would hope, a lack of innovative tech providers making headway into this market. And from speaking to vendors, the bar is seen as a fragmented, low-volume market. And the perception is that the market isn't particularly suited for disruption or investment. Speaking to barristers, their tech learning is mostly ad hoc. There is limited formal support or training for barristers across the various career stages, and awareness is low of potential applications. So there are possibly opportunities here to share information on useful practical solutions. The risk of things going wrong wasn't significant, taking all the interviews into account, but it was an issue for some. And really, I would sum this up by mentioning isn't so much barriers to adoption as really an absence of drivers as well. Most respondents felt there was low demand from their clients, from the courts and from law firms, except where compliance is considered. But there is a sense that there are no drivers for change. So just to sum up, the key themes, really, I would say that we've seen quite patchy and inconsistent implementation of technology at the bar, with adoption varying greatly. Larger chambers and the employed barristers have more sophisticated technology infrastructure and well-developed back offices. It's a different story for the pastoral, for the crime barristers and other legally funded practice areas. Barristers' workflows are not standardized. Unlike solicitors' firms, barristers don't have the benefit of the economies of scale running tech solutions over a large volume of data or headcount and the efficiencies that offers. So with that in mind, we pose some questions that may prompt some thinking from you, as well as hopefully drive some discussion by the panel. So finally, in terms of recommendations, and I would stress that these are for the whole sector and other professional bodies to consider, not just the BSB, but these are some potential areas that could be explored in order to create an environment conducive to technological progress. I'm not going to discuss all of these, but would just bring out 3 of the main points. Number 1, potentially a need for more standardization, for a more joined up approach, including the courts and the judiciary. One barrister commented to me, he's really not thinking about innovation, and AI is all he wants to do is get to court and hope that the screens work so he can show the evidence that he needs to show. Second, to explore ways in which we could increase awareness for the bar on the technology that's available, whether this is a CPD or a people group or online training or other ways to share opportunities and benefits of technology in a small and practical way. And thirdly, number 5, client needs. A limitation of this research is that we didn't include law firms or clients in this. We really wanted to focus on the profession and the tech vendors. But clients and law firms are obviously key groups who need to be engaged in drive social change. So in conclusion, the research shows there's real potential for barristers to drive efficiencies and hopefully deliver greater value to clients through the smart use of technology. I hope these insights have resonated with your own experiences and ideas. With that in mind, I'll hand back to Ruth to continue the discussion.
Thank you so much, Gemma. So I think in terms of research, that was a fantastic snapshot. And I think the number of people here today in the room and online is a testament to the relevance of the research and an interest in the area overall. So thank you so much. In terms of the panel, we're going to kick off really by looking at innovation itself and how change happens. And then we're going to move on to technology and how that can fuel growth and efficiencies. I'd really like to start off directing out to Alex, who's joining us remotely. So Alex works at LawTech UK, which supports digital transformation for the whole legal services industry. He's also involved in teaching and research at the intersection of law, philosophy, and innovation. So Alex, I wonder if you could briefly talk us through the innovation process, what it means for barristers when adopting new technology.
Be the way, Harold.
Sure. I hope everybody can hear me in the room.
Perfect.
I can only assume so. So first of all, congratulations to the Bar Standards Board for completing this very important and long overdue research. The work is great. In terms of the Rogers' model, this is a model that describes how, why, and at what rate new technology and ideas spread through the population. So as you can see, I'm not sure you can see it on screen anymore, but what just popped up on a slide, Rogers distinguishes generally between what he calls the majority, and that's both pragmatists who act on proven benefits and skeptics who adopt tech when necessary or where its benefits are being proven, and the rest. And that rest includes innovators, early adopters, and late adopters, so basically radical ends of a spectrum. And in principle, I agree that there are stages to technological progress, but there are a few caveats. Firstly, Rogers' model was developed when a pace of technological change was much slower. In a current era, particularly in technology, the stages might compress, they may overlap, they may manifest differently. The fusion of tech is nonlinear, it's iterative, and there are also significant external factors that are sector-specific that may affect the curve. So I like to think about Rogers' model as a measure of comfort with two basic things. It's risk and uncertainty. And those two can be fluid, and people are certainly not stuck in one group or another. I myself find myself routinely on various ends of the spectrum, and it really does depend on the specific idea or a project. And for that reason, and I think at the bar this is particularly important, there is really no need to ostracize late adopters or skeptics. There can be very, very, very valid reasons for including systemic issues or simply poorly articulated value proposition for not adopting new technology. So with that said, I really do agree that the bar is definitely ripe for the kind of innovation that we saw in other corners of the legal sector. I've always said this, and I stand by this, that the value of this market has been historically underestimated and the scale of this opportunity has been poorly understood. And it might be because the bar's perceived conservative nature may attract people who are generally more risk aware or time poor predominantly, meaning that the startup move fast and break things mentality may not be as that is so conducive a transformation may not be as easily adopted. And so adding to the research findings, I would say that first of all, you don't need to be a barrister to innovate in this space, and that's super important to highlight. Secondly, chamber structure and the general mystique of the bar may make it harder for innovators to enter the market because it will take them more effort to identify and clarify potential scalable use cases. So we've seen this at LawTech UK before, where individual barristers and clerks may not have the same level of enthusiasm for technology, and that can cause friction. But that's not too dissimilar to what we've been seeing with in-house teams and solicitor firms. And as a final note, while the curve may be helpful to conceptualize adoption of tech, I think barristers really can benefit from the expensive lessons learned by especially big law firms, and that may perhaps draw more traffic to general adopters.
Fantastic. Thank you so much, Alex. So that was a brilliant overview of innovation and how it works. Andrew, you're both a barrister and an entrepreneur. I'd love to ask you about how your experience of impacts the kind of technology you adopt in your own practice.
So I was thinking about how to answer this. I've been doing this stuff that we practiced 30 years. And so a lot has happened in 30 years in terms of technology. And I think you can just drop into three buckets the different types of technology that have changed my practice. I endorse what Gemma's research said about technology hasn't necessarily made the job any easier. It's made it more demanding. Clients can now, first thing you do in the morning is check an email. It used to be the case that I wouldn't get hassled until I saw what faxes had come in overnight when I go into chambers. So I think we're at that point in life where the demands of the client have become accelerated and the stress has become more accelerated, but the tools haven't made the job, the rate of improvement of the tools that help me do the job haven't kept up. I think that's what's going to come. And that's what AI, I think, is going to capture. But I think there are three buckets. I'd say that the biggest influence on my practice technology-wise are things that have just happened to the general population. Internet, email, cyber security. We now market through website. Cloud is a big one. I'm no longer carrying around a floppy disk to plug in when I want to print something or want to work something at home, all that sort of stuff. But that's just general technology. And I think the bar adopts that as fast as anybody else. I don't think the bar's behind in that sense. Then there is the stuff that's legal sector specific, but not specific. So those are the sort of the document management systems. I've already I don't do a lot of litigation, but when I did some last week, and it's the first time I've done a trial with no paper, and it's fine. And there are those sorts of tools. But again, they're adopted because generally, as an advocate in litigation, you're part of a team. It's not a sort of completely separate profession anymore. You're much more part of a team with the law firm. So all of the technologies whereby you can receive your book, the whole team's working. So that's all again, an important bucket. And then if I think about, well, what is in the bucket of bar specific technology I've adopted, it's sort of like, well, you need an egg cup, not a bucket. Literally, the Chamber's accounting system and the Chamber's website. And I don't necessarily think that's a bad thing, because I'm not entirely convinced there's a massive need for bar specific technology. And the point that was made in the report and Alex picked up is you've got to bear in mind we've bandied around the numbers. I think that something like 14,000 employed barristers is different. I think independent barristers about 14,000. So if you think about that market at 1,000 a head, that's only a 14 million market. That's not a market that's going to attract innovation. So
I'd like to come back to that point a little bit later. We'll come back to that specific point a little bit later, but moving on now to Chris, a couple of people have already touched on it this evening. In terms of the evolution of technology, the pace of change is getting faster and faster. So how can barristers get the digital skills that they need in the first instance and keep those as they progress through their career in terms of being able to use technology effectively in their practice?
I think this is a really interesting point, and one that the report does help us with understanding. The findings reinforce prior research on technology diffusion that identifies on-the-job training as a significant positive factor in technology adoption. Training helps support both the adoption of new technologies and also then the integration of them into processes and the effective integration of those into processes. What we can also see from the findings is that, as you perhaps might expect, within the bar, there is a high degree of individual agency and autonomy in relation to tech use at the moment. But the findings also suggest that practitioner agency is somewhat of a double-edged sword. It enables individual flexibility, agility, and pockets of innovation that have been noted in the report, but it also then creates challenges for collective adoption, standardization, and systematic training across the bar. These challenges are potentially likely to contribute to technology adoption being varied and often isolated. So the findings also identify a lack of specific technology training in traditional routes and the preference for self-directed learning as potential hindrances to that widespread adoption. And what we're also seeing is that the variation of technologies used and the rates of take-up vary hugely across the sector. Now, absent programmes of standardisation enforced by the courts, it would seem that the training needs required will vary dependent upon the range of needs to ensure ultimately that, first of all, the tools fit the purpose, and then also individual levels of technology usage. The report indicates that barristers already recognise the value of building digital competencies to be able to exercise agency over their use and selection of technologies, and also flexibility within the level and delivery of training. Thinking then about how to potential ways to frame training offerings, we might begin, as we have, with an overall framework for digital competencies that outlines digital competencies across a range of areas, building from your very basic practice, basic and practice technologies, through to understanding emerging tech, data, uses, risks, regulation and management, as we've heard in the report, is a key thing. And then also looking at streamlining practice and automation and efficiencies. Now you can take that right through to contextual literacies. And I think this is really key here, focusing on ethical impact and how these crucially intersect with the core duties and the professional statement. Now, in terms of implementing that, the BSB already have a really well-structured framework around CPE, both for newly admitted barristers and existing practitioners, and significant flexibility within the existing practitioner scheme. So introducing this wouldn't need adaptation in that respect. What we can see from the findings is a need to ensure that whatever training is provided flexibly and in a way that supports the diverse working practices and areas of focus. I would say that the nature of the training is also important. Prior research has shown that adaptation to new technologies often involves complex cognitive processes, which the bar is very good at, and that training can actually shape participants' perception of a new technology and also influence their attitudes to change. So the way that it's framed is more than just detailing the tools. To my mind, the way in which training is shaped and delivered is crucial for the bar, and not simply about reiterating what tools are available. It should consider technology from a rounded perspective in terms of what works for individual practitioners, but also the responsibilities of the profession and the regulatory objectives of the BSB. It must take a balanced approach that takes into account the way in which technologies impact upon the core duties, for example, ethical risk and impacts of different types of technologies. And ultimately, it should support the development of agency and the ethical judgment and decision making that the bar is valued and respected for.
Thank you. And looping back to one of the points Andrew made and moving on to you, Gemma, the bar itself is a small market in terms of, I believe, 15,000 a day. So how do you see any other existing services being adapted?
I think we all appreciate that the structure and the workflow and the needs, the processes at the bar are very different to those firms. And the majority of tech solutions that were covered in the report are really don't necessarily work for a barrister's workflow, which is quite exotic and creative. Technology for barristers needs to be lightweight and mobile friendly and compatible with their existing systems. Pricing in particular needs to be accessible. Pricing models don't work on the whole of chambers because chambers don't dictate to their members, what they are using. It's down to the individual barristers who get to be on board. So rather than offering support and change management, I think vendors could think about delivering solutions that actually reduce the time that barristers spend on us, make the work more efficient, offer a better work-life balance, and bill more. And the evidence suggests that barristers will get on board. I also think the relationship between solicitors and barristers is really important. We're not necessarily talking here about barristers using tech tools as individuals, but really as part of a law firm team, really collaborating and using all those amazing data science expertise to have a better outcome.
Fantastic, thank you. So Chris, coming back to you, and given everything we've covered, how do you see tech changing the services that barristers can provide? And what does this mean in terms of unmet legal needs?
Yeah, I mean, I think there's a number of ways that the services could change, increased ways to connect clients with legal services. We've seen technology platforms that do great work in connecting individuals to legal service providers, including platforms that match those needing legal aid with pro bono providers, or enabling direct access to barristers. Affordability, while the BSB report notes that market characteristics mean that the bar may not drive efficiency unless necessary, in theory, tech efficiency gains from technology could make legal services more affordable, thus addressing greater legal needs. But we perhaps shouldn't assume that more tech necessarily means more access to justice, although access to justice is quite frequently mentioned in many conversations around technology. We aren't seeing a huge range of innovations that support that come to fruition. Technology development is costly, so technology development will focus on where gains can be made in the market rather than perhaps the societal usefulness of the profession or the regulatory objectives of the BSB. We see the findings of the report confirming this development bias, actually, in that there are lots of products that are focused on providing solutions in areas where the money is. So if barristers are not where the money is, those who can't afford legal aid or legal advice are unlikely to be identified naturally as a development priority for tech. Saying that, access to justice and increasing public understanding of legal rights is a regulatory objective for the BSB. So the interesting challenge, I think, is for the BSB is that are there ways using technology that the regulator could better support the profession in achieving those aims? And I think that that's an interesting space for us all to contribute towards.
Fantastic, thanks, Chris. So final question for Alex before we loop back to the audience here in London and also who've joined remotely. So Law Tech UK is helping to grow the legal sector's economic contribution. Could you talk a little bit about the support you give specifically in terms of tech development?
Sure, thanks. And so just to quickly respond to something that Chris said, at Law Tech UK, we've seen actually quite a lot of really great solutions coming through from the B2C space that target unmet legal needs crisis. And this is really becoming the paradigm in that space is really shifting. We're noticing some different conversations around capital raising and making some of those solutions commercially viable. But fundamentally, what I would highlight here, and this is also something that we've seen in the past, is that the bar is always or it may be the missing link in a digitization of the legal space, particularly in respect of the B2C context. I would also say that there are certain challenges in the unmet legal needs in SME space that are actually universal across the bar and the legal sector. And one of it is that we need a radical systemic change in how we consume and define legal services. So in order for any tech to be scalable, we need to make the legal process both clearer and easier to define. And then we can think of technology to support those in need. So this is the work that Law Tech UK has been doing for the education programs, through mentoring, through a variety of different initiatives that we would love to talk to any participants in the event about. So please reach out. I would also add that scaling at the bar bears very similar concerns generally that have been raised when it comes to scaling in A2J or B2C legal. So your scope as an entrepreneur is very much yours to define. And sometimes it is about going big or going home, which is one of the challenges, I think, in anything tied up to a greater system such as the courts. The bar is also not homogeneous. And this is, again, something that we keep speaking about to the aspiring and advanced entrepreneurs in the space, that there's a lot of room for innovation from both, starting from practice management to client onboarding. And you can develop tools that support litigators of all backgrounds. And here's also where the more generalist law tech may shine. But the challenge that we see all over again will be the need for perhaps more custom solutions, more integration. Digitizing the bar may be closely linked with digitizing the court system, for example, and that is not something that is easily resolved. So there will be occasions where Scaling at the bar will be a question of reaching no one versus capitalizing on enabling truly systemic change. And there is a universe in between, but I suspect it will be more profitable to providers who innovate across professions rather than necessarily focusing on those super narrow niche use cases. And so as a parting gift, please come speak to Lotec UK about building out your idea if you're thinking about innovating at the bar. We are, and I'm sure that many of us will feel greatly inspired by the BSB research. It can be seen as a tiny market, but all of that really depends on your perspective and appetite for risk.
Thanks so much. That's a brilliant invitation from Alex to anybody in the room who's interested. So I'd like to open out now to questions. We'll start off in London in the room, and then we're going to go online. Does anybody here have a question that they'd like to ask anyone on the panel?
Hi, my name is Ali. I am founder, well, Early Bird Start founder of Jury. I have a question for Andrew. The question is, you mentioned about the collaboration, about how solicitors and barristers are now shifting towards more collaboration approach. What specific processes or tools have enabled this kind of shift, and what kind of gaps are there in the market that are?
Well, I think it's been happening irrespective of technology. I think that evolved 15. I think it's much more part of the team. But in terms of technology, it's this sort of we always used to worry when solicitors were given the opportunity rights of audience. It's either going to come and start doing. Then what I find is that some of the things that may be historically, like somebody talked earlier about chronologies, quite often now the barrister won't do that. There's not the same sort of bright lines between what the solicitor does and what the barrister does, apart from the advocacy, and it becomes much more of a team effort. And so all of the technologies that we find really helpful are the collaborative bundling things, so the Opus 2s and all that sort of stuff. That's all really helpful. In terms of gaps, in terms of if you're trying to find where a gap is to launch something, I think my concern is that we focus too much and say this is specifically needed for the bar. Why is nobody innovating specifically? Why is the bar not doing anything specific? When in actual fact, they use a need is no from their client, the law firm. Things that help them collaborate together. I think service everybody, because we're not sort of, it's not this idea that maybe it was where people would, the solicitor's job we'd done, they tie the pink ribbon and send them. I mean, the DX has gone, hasn't it? DX has sort of pretty much gone now. It's sort of where it's passed on, and then the barrister does something, and then either they appear in court or they write their advice on the document, tie it up again and send it back. Those days are gone. It's now a sort of single. So I think I would say I would dispute the idea that the bar's not adopting technology. I would say the bar's adopting technology in the same way as everybody else, but there isn't necessarily an independent user case for the bar that isn't the same for the underlying clients. And the client doesn't want this idea of disjointedly. He just wants a solution to his legal problem. Just as the barrister sort of slots into a bigger team, then the technology they use has to slot in as well. We can't have this idea of somebody searching the documents at the law firm using one system, then it coming over to the barristers as raw data and it being done a second time. That's just duplicate. Pointless. That's all going to be done through one system, and it will be a system that probably the law firm has that they give access to. So if I get a bundle now for court, I need too big for now. So you just get a log into whichever system the law firm uses. Take it down, and that's access. You're not thinking, oh, I need to have this system myself, because there's no user case. So I think my point is really that you're not fundamentally as sort of on your own as perhaps you once were, and therefore sort of piggybacking on technology that law firms are using actually caters for 90% of the user cases.
Thanks, Andrew. So moving now to online. Are there any questions online for us to respond to?
We had a few questions. They're all relatively separate, so we'll maybe treat them one by one. But The first one's in relation to AI, are there concerns in respect of data protection when using off-the-shelf products like ChatGPT?
Can I hand that one to you, Gemma?
Yes. I think most of the barristers that I spoke to are very literate with GDPR and data protection. It is absolutely bread and butter for everyone that I spoke to. And I think they are fully aware of the requirements. And as far as I could tell, as far as they would say, using everything in a very compliant way.
Thank you. So back to the room. Hi.
Hi, I'm Joanna Goodman. I'm the tech columnist for the Law Society Gazette. I'm interested in the size of the sample of the research, because if there's 14,000 practitioners, it seems a very small number of qualitative interviews. That is 42 interviews who are practitioners or stakeholders, and only 5 tech vendors. I'm interested in how that could genuinely be representative of a population of 14,000.
Are you okay?
Yes, absolutely. Well, I think that was our specific intention from the beginning, to have a qualitative approach to it rather than quantitative. There are mechanisms out there to survey the profession. We didn't really want to go there in terms of delivering 75% of people are using this or 25% are doing that. We really wanted to expose the themes, and I think we've done a good job of that. And I feel like the interviews that we conducted were enough to get us to where we are. Obviously, there is further work still to be done. I've mentioned we could follow this up with a quantitative survey. We could include law firms, clients, wider stakeholders in that. But it was always intended to be
But thank you for the question. And when we wrap up, we're going to talk a little bit about some of the next steps and what's going to happen in the future. So Henry, back to you for another question online.
Yes, the report mentions, this might be another one for Gemma, but the report mentions an absence of facilitation with and training on tech for the profession at all stages. Did the research offer any insight regarding the training on tech at the academic or vocational stage of training? This also might be a good place for Chris to come in.
Yeah, I think it was probably for Chris in terms of the on-the-job training was definitely the biggest theme that I took out of it in terms of comments.
So Chris, over to you.
Yeah, so I mean, I think I spoke already about that need for training and how that might be structured. In terms of the academic stage and educating the next generation of barristers and responsibilities or opportunities for training and education providers. The significance, I think, here is that for the profession to adapt, training must continue to, first of all, develop and reinforce those high-level skills that are required by work at the bar, alongside developing technological competences as appropriate. It's going to be key for education and training providers to contextualise the understanding and use of technologies within the core duties and conduct rules, and in terms of the professional statement, for example, under the skills and attributes. I mean, you can already relate technological competence to a range of the skills of attributes. For example, sufficient understanding of organizational practice management skills, and also practicing with adaptability and flexibility. So you can see how that could be fitted into the training that is offered already, both at academic and vocational stages. Yeah, I think that maybe covers it.
Fantastic. Thanks, Chris. So moving back to the room here in London, we have a question in the front row.
Actually, it's picking up on what Chris was just saying. My name is Amanda Lord. I'm working with David Blaney on Associo, which is one of the tech providers in the report. And I think what Associo is trying to do picks up on one of the themes that's come out tonight, which is around collaboration, in a sense, and training. No one likes to be taught, but everybody needs to learn. This is such a new area, such a fast-moving area. But for the bar and for law firms, this is actually, it seems to me, a brilliant opportunity to collaborate in the learning and for maybe the BSB will pick up this baton and run with it, but to allow that sort of joint learning around this, for barristers to be learning alongside their clients and vice versa. We're all learning really. And actually what we're all looking for, I think, are ways to solve the friction points, some of which Andrew mentioned, and that's, nobody wants a shiny solution in search of a problem. We need tech that will address the friction points, and many of those friction points are between barristers and solicitors. I've asked for this, it's not what I wanted. Oh, well, you weren't clear about what you wanted. Oh, well, I can't reach the SharePoint. All of those things, tech ought to be able to help with them. And what Associate, and I'm sure lots of other tech providers are trying to do, are find ways to enable all of us to work better together for the client and to make it a better product and a better journey for all of us. So I guess my question to all of the panelists and to the BSB is, can we all start looking at the opportunities more than the problems, and seeing this as an opportunity for all of us to collaborate and work better together, not necessarily be trained, but learn together.
Thanks, Amanda. That's a great point. I think I'd like to hand that one to Alex. Alex.
I get the hardest question. How's that possible? I think this wider piece on collaboration is something that LawTech UK as a Ministry of Justice funded program has been attempting to do for years. We've coalesced a really good community of both practitioners from all corners of the legal universe. And we're seeing that the magic really does happen when we come together. I think that there is definitely more scope for knowledge exchange. We have one of the programs that we run at LawTech UK is called The Bridge, where we put incumbent companies or larger corporates together with startups to both share knowledge, gain new lessons, gain, that the corporates may look into gaining more of what we call the startup mentality. The startups may learn more about procurement processes for corporates and change management processes. And we found that to be really not only rewarding for participants, but also just conducive of a better LawTech ecosystem. So I would say that there is no really easy answer other than putting people in a room around the same goal, and sometimes mixing the enthusiasts with the skeptics. That really does work wonders, and changing the attitude of, as I said in the beginning of today, changing that attitude that people who are late adopters should be ostracized. Not at all. We can all learn from late adopters, very much the same way that early adopters we can all learn from pioneers and innovators. It's just different lessons. And the target of putting people in the same room may seem harder than it seems. It's much easier than it seems.
Fantastic, great answer. Thanks, Alex, for taking the hard question. So I'm going back to Henry now. Back to any further questions online.
Yeah, there was a question about the BSB's role, and obviously we're in BSB building today, and it's a BSB to talk and all that, so it might be helpful to address the elephant in the room. The study didn't find regulation as a barrier to tech and AI, but perhaps even in the spirit of Amanda's question, what role might the BSB play to address those barriers? And a few things that have come up in the chat have been around targeting consumers, have been around things like setting minimum standards, things like addressing qualifications and things like that.
Gemma, would you like to add from the research? And then Andrew, I'm going to come to you.
I suppose slightly coming back to Joanna's point, we spoke to 30 practitioners, and those practitioners did not feel that regulatory requirements were a barrier. And likewise, the tech providers didn't say that regulation was a hurdle in terms of development. And we could find different responses. But that does tie in with the LSB survey that we did, that was 2023. So I think it's probably over to the Bar Sanders board to comment on the rest of that.
Well, I was going to, in the spirit of, being positive and think about the future, ask Andrew, what would you like?
I mean, again, I much like the research, don't perceive any particular issues prevent get in the way of my practice, or indeed what we're doing business-wise. I think it does become more important, as a few people and Alex has touched on, about when we look at services provided directly to consumers and how those are regulated. I think that's a whole different ball game. And I think technology does create a real opportunity and to improve the lot of the average person in the street who wants to understand. It's a slightly odd thing that in a democracy you can't necessarily understand what apply to you very easily, and you have to pay somebody to tell you what the position is. So I think this technology is coming along will create massive opportunity for technology coupled with good data to make information more democratic and cheaper for small businesses and things to achieve, and that will undoubtedly require questions, regulatory questions about who's providing the data and all that sort of good stuff. But I think in terms of are providing products into to law firms and so forth, and indeed barristers using technology, I don't really think there's any impediment. Research board, but I agree.
Great. So one more question in the room.
Just add to, I think what Andrew said again very eloquently. I think one of the things that are sell itself well as a profession. So again, you've got to be careful of what bar can actually promote, but this is where innovative barristers are making ways to promote your craft, even those that do that. Be a signpost. So where is that legal need? And there is still that legal need of 3.6 million people that they're going, 2 billion that's wasted on this. But the most important thing is we are £3 billion entity of a £40 billion legal spend per year, where solicitors are 25, other legal providers are 14, 15. You ask anybody who is the elite lawyer that you would like if you could afford a barrister. Why do we not promote ourselves? Legally, we could do that, but it's only entities that Andrew's doing. So is there a register potentially that you can't, the regulators can't promote, but potentially could an option? That's a list potentially signposted. Those that need to then rely upon where we could be signposted, and then that promotes the potential opportunity for others to innovate and services.
Really great point about growth and the potential opportunity. We like to put that.
But Gemma particularly about, I'd say Andrew, who's done it.
Well, I mean, the way that we thought about this is when somebody, whoever it is, has a legal problem, there will be somebody somewhere in the UK knows the answer. And at the moment, the chances of the client getting that person to answer the question very quickly, and that virtually zero. Because how do they find that person? What they're most likely to do is ask a friend, do a Google search, go and instruct a local firm of solicitors. Then they might not know the answer. They might know which counsel to go and talk. It's all really inefficient. So the technology is undoubtedly going to improve that. There isn't anything out there. I mean, I think, as Alex said, there are people looking at this market. I mean, I'm encouraged by sort of seeing the funding rounds that people are targeting these markets, and we're certainly seeing that we license our content to some of the big AI companies. Go back to the question, all on a walled garden basis, can't be mixed with anybody else's. Firms are not entitled to put our data into any ChatGPT or anything. Restricted. But as we're getting increasing requests from people who are targeting the direct to consumer market who want to access our data for that model. So I think people are absolutely looking at that. But it's going to be that how does client X find barrister Y or solicitor Z? It doesn't really matter. And at the moment, it's fluke. And I think technology will, how it will solve that problem, but eventually that will be cracked, and at that point a lot of wasted costs for everybody disappear. And
there's a classic there in the sense that very question is that the last 7 years I've developed a platform which is going to introduce and its management system, so-called barrister. However, the regulator that can't promote the possibility that you could connect that makes the end user easier, less costs to connect to that right barrister that's going to make that difference. And so how do we suppose how do we promote what we do in the barrister world, clerks world, to promote what we do compared to what seems to be.
The barristers answering the questions are going to want it fed to them. So they're not going to market. Nobody goes to the bar to market. And they don't. I think somebody raised the point earlier about training. You know, every hour you spend marketing, people maybe the wrong analysis, but the way most barristers think about it is that's lost money. So that it's not. You know, that's quite a naive way. That's the. So the barrister's going to want the worst to just have something pinged to say, oh, here's something that's right in your wheelhouse. I can answer that bang, and that's what it's going to want. But it's not going to be straightforward.
No.
You're you know, it's like anything else, like any other sort of dating service. It's going to be quite good. And barristers don't want the plastic bag thing of, you know, direct act. Reason people don't like direct, so they don't want the plastic bag. When it says, I've got this issue. People don't come
out
to
last. It's worth the direct access. Yeah.
So it's difficult. It will happen. Else, but it will happen, and lots of people are very driven to try and solve.
Fantastic. Thanks, Andrew. Gemma, did you want to add?
No, I suppose I was just reflecting on the conversations we've had about training and whether this should be at various vocational stages or pupillage training. But I think actually a lot of it is just generally raising awareness for the barristers of what solutions are out there. And I think the demand that I saw from participants was really for small bits of practical help that will enable them to understand what's out there instead of having to look across the courtroom and say, well, really bring those benefits. And I think that's something that would be quite easy to do, whether that's a regulator or other, just to help raise that awareness.
Brilliant. Well, I'd like to thank everybody here who's joined us this evening and panelists, and I'll hand back now to Mark.
Thank you very much, Ruth, and huge thanks to the panel. I think it's been a really fascinating evening's discussion. There was a question about, you know, role the bar standards play. I think above all, the bar standards board can play a facilitatory role here. We are already working with the Bar Council, set up a joint working group to look at how collectively we might address some of the barriers to the take-up of technology, particularly the scale barriers. I think we should definitely look at the issue of training. We now have a regulatory standards department that is looking at what it means to be a barrister, and really what it means to be a barrister is going to be about literacy of technology, diligence. And I think, you know, another of the kind of really interesting themes of this evening has been the need for collaboration between the bar and the solicitor profession. It's a point that Andrew made. I think very forcibly that actually it's that collaboration that drives the take-up of shared technology. But above all, I hope that this evening is the beginning of a continuing dialogue, and that we can. Huge thanks to the panel, but of course, huge thanks to all my colleagues in the background who have made today possible. I won't try and name them all individually, but you know, they know who they are. I've done a fantastic job of setting up this evening. Thank you all very much.
Thank you.